To last lecture, we had discussed the second chapter from the Maharashtra Land Revenue Code. Now we are going to proceed the last part of the Land Revenue Code, that is part 3 from the MLRC. And first chapter under this part 3, we are going to discuss, that is the record of rights. Uh, Chapter 10 from your book, that is deal with the record of rights. Uh, Now, what is this record of rights? Because most of times we are going to confuse, rather most of the students they are going to confuse, because in this chapter itself, that record of rights, we are going to use the word revenue records or the mutation entries, and what is the concern of the record of rights. So when you use the word record of rights, uh, at the beginning itself, let me clear one thing. It's a combination of entire things. So it's a entries, or it's a record created by the all the revenue authorities, not only those who are dealing with the revenue, but also the right from settlement commission to the lowest officer who is dealing with the survey and all this aspect. They play very vital role so far as this chapter 10 is concerned. So when we talk about the record of rights, it is not only because only that the revenue entries which is created on the seventh extract or the on the 8A extract, it includes the entire things. So the beginning, when we start the introduction part, so far as the record of rights is concerned, as we are aware that the in earlier days, the revenue is the important source of the state. So far as the income of the state government is concerned, most important source, right from the uh, Retwari, Aniwari, all these systems, they are dealing with the collection of the revenue from the agriculturists. So land revenue is the most important source of income in earlier days. Once we got the independence in 1947, of course we have changed several laws, including the land laws. In this law also we have carried out certain changes. But what I'm trying to show is that the even though earlier land revenue was the important source, however, due to increase of the population, the use of the land has been changed. So from the agricultural to non-agriculture. So when it is from the agriculture transfer from the agriculture to non-agricultural purpose, then the person who has carried out the change, he has to pay the change of use fees. So that is more than the land revenue. So government realized, instead of land revenue, there are other sources of income from the land also. Like, let us take the example, like in cities, we have to pay the taxes when the land is used for the non-agricultural purpose. But when it is agricultural purpose, we have to pay the land revenues to the state government. If you go to the quantum of the land revenue and land record, you will realize, I'm sorry, the tax and the land revenue, you realize the taxes which was again fixed by the government so far as non-agricultural land is concerned are much higher than the land revenue, because we have already discussed in settlement and assessment that it depends upon the fertility of the agricultural lands, so far as the use of land, the crops which has been taken, the source of water, all these aspects has been considered, and then the government officer will fix uh, the assessment for particular land. So far as non-agricultural use of land is concerned, the value is higher than the agricultural land. So on this aspect, we are going to discuss this part, and we are aware that the so far as the importance of land revenue records are concerned, we are aware when you want to purchase the property, the first documents we verify is the document of title. And even though legally speaking, the cemental extract or other revenue records is not documents of title, but as a practice, we firstly see whether such a person has a right to sell the property or not. And the first document we verify, so far as agricultural land is concerned, that is cemental extract. So what we can say, record of rights is an important document for investigation of the title. I'm not saying record of the ownership. to investigate the title of the person, whether such person who is going to sell the property, he has a title over the property or not. Then we have to go to the record of rights, and that record of rights is kept by the government authority or government officer, especially the revenue officer who are working in the revenue office. And they're keeping certain register, that registered, the register is title and different under the different laws. There is a registered college, register of record of rights, and register of the crops. So it is whose duty? The lowest officer, so far as this hierarchy is concerned, who is dealing with the record of rights, that is the talati. He is responsible for taking up all these crop entry and mutation entries, and the again amendment in mutation entry or change of mutation entry. He is responsible all these aspects. So under this chapter, we are going to discuss all the record of rights provided under the Maharashtra Land Revenue Codes. And Maharashtra Land Revenue Codes has provided different kinds of land records and the hierarchy of the officers. When we talk about the hierarchy of officer, of course, it is divided into two parts. One dealing with the record of rights, and other dealing with the collection of the land revenue. So when it deals with the different aspect, then we have to discuss the three different hierarchy of the officers. Uh, as per the Maharashtra Land Revenue Codes, there are three kinds of land records. Firstly, the various village forms of land records. Village forms means there are different village forms available under the Maharashtra Land Revenue Codes that provides the entries that is kept for the making the entries in respect of the lands. One of the form, as it is popular. Of course, there are several forms, but one of the form is 7 extract. This is one kind of the form. Secondly, the maps. Now that is why in the beginning itself I'm saying 17 extract we can understand, but so far as map is concerned, we are aware this is the purely work done by the the other machinery, that is settlement commissioner or the district land record officer, or TILR we call as Taluka land record officer. So maps, survey numbers, then the survey number prepared under the Maharashtra Land Revenue Code. This also includes in land record I'm talking about. Apart from this, the scheme that is provided under the uh, Town Planning Act, that is the scheme, town planning records, the maps, the planning scheme, then the improvement scheme, what is we call it DP, development plan. All these aspects which are being covered under the definition of land record. Let me clear one thing: land record is different than land revenue. I'm sorry, the record of rights. Land record is different than the record of rights. Record of rights is only by the revenue authority, but when it talks about the record of rights, that is purely done by the both the officer, revenue officer, and the survey officer also. So all this included, so far as the Maharashtra Land Revenue Code is concerned. Now, when before we go into the further procedure, we have to go back to the definition part, and we're aware that the while defining the certain provisions under the land revenue code, we have discussed one definition that is under section 2 subclause 18, that is with reference to land record. And the definition of land records provides that it means it's a record maintained under the provisions of this code. So who has and who are responsible? There are two kinds of officers. One is the survey officer, other is the revenue officer. Survey officer that dealing with the carried out the surveys, the measurements, and creating the maps and survey numbers, whereas the revenue officer dealing with the collection of the revenues, the mutation entries, improvements, change of the use of the land. So these are the two machinery which are working together under the Maharashtra Land Revenue Code. So section 2 subclause 18 deals with the combination of this. The land record includes combination, that is all the records which is maintained under the provisions of this code, which includes land record also. And therefore the record like the copies of map, the copies of the survey record, copies of the plan, the scheme created by the government or development plan by the state government, that also included in the land revenue records. Now, so far as the hierarchy of the Department of Land Recording concerned, because when we start the other discussion, then we'll discuss the hierarchy of the land revenue. But so far as the hierarchy of the Department of the Land Record is concerned, it is again the system from the higher to the lower. And wherever in the lower itself, there is an officer called as the Taluka Inspector of Land Record. See the when you enter into practice, you will going to cross this gentleman. We call as the Taluka Inspector of Land Record. That is, he is working in the Taluka level. Of course, the other officer like Talati and all this revenue officer will help him, but the Taluka Inspector of Land Record, he dealing with the survey numbers and demarcation of the maps in the taluka, all the villages in taluka. In short, we call as TILR. Then in the district level, we have the another officer called as District Inspector of the Land Record. This is the other authority we have so far as the land record is concerned. And at the state level, we have a director of the land records, and there is also post called as settlement commissioner. So, what is this director of land record and settlement? We'll discuss. But this is the hierarchy of the so far as the land records in the under the Maharashtra Land Revenue Codes are concerned. Now, after discussing this first step, so far as the land records are concerned, we are proceed with the record of rights, and we are aware that at the this chapter particularly deals with the land record. But when it talks about the record of rights, it deals with the land that is which pays the revenue to the state government. And the basic object of this chapter is the chapter and the all the land records or the revenue record is to ascertain the ownership. I'm not saying the title. Who is the actual owner of the person, to ascertain the ownership of the land. That is the main object of the, and to collect the revenue. Of course, this is another object of the land record. Similarly, these land records are useful for what purpose land has been used. Because when we proceed further, you realize that whenever uh, any land record the entries has been made in order to ascertain the ownership, the crops, the quality of the lands, all these aspects can be you can ascertain from the record of rights. And as we have discussed, there are several forms. There are 16 village forms available under the Maharashtra Land Revenue Codes, and one of the form that is uh, form is 7 to extract. And at the beginning itself, let me clear one thing: this particular form, to maintain this form, it is the duty of the talati to maintain all these 16 forms. Of course, all these 16 forms are with the different aspect and different objects. It is not that the at one time it has to be filled up in respect of one land. No, the object of the form, the title of the form, or the subject matter of the form is totally different. So when it talks about the ownership, form is different. When it talks about the crops, form is different. When it talks about the dispute, form is different. When it talks about the entries of the tenant, form is different. So that is what we are going to discuss. But the so far as our point of view is concerned, let us discuss one by one form. Of course, we are not discussing all the forms, but three, four forms which we are going to discuss. The first form is the village form number 7. So in general life, several times we use the word 712 extra. ज्याला आपण मराठीत सातबारा असं म्हणतो. Why it is 712? Because 712 extract is a combination of two forms. One that is 7 and form number 12. And therefore it is called as 7 multiplied by 12. That is 7 and 12 form. So what is this 7? Form 7, it's a called as register of mutation. Form 7 deals with the register of mutation, and mutation means the substitution of the ownership. This substitution of ownership by the different ways, like sometimes by the transfer of property, sometimes by the act of the I'm sorry, act of the law. Let us take the example. When this form or entries in the form is mutation entry has been created. If suppose it's an ancestral property. After the death of the father or the owner of the property, name of the legal heirs will be recorded in the place of the person who was dead. This is by act of the law. I'm sorry, the God. However, in case of the act of the human being or act of the person is concerned, when the owner transfer the property by any of the method provided under the Transfer of Property Act, as we know there are five methods. If he sell the property, then the name of the person has been inputted. Apart from this is what the Form 7 is concerned. And especially section 148 to section 151 and section 154 of the Maharashtra Land Revenue Code deals with these forms 7 of the Maharashtra Land Revenue Code. And apart from the sale, if the ownership is transferred by the will, exchange, then we call as the lease, gift, inheritance. All these entries has been made by the mutation in the form number 7. That is we call as ownership column. We generally we call it the column of ownership. And come to the form number 12. Of course, before we proceed to form number 12, one of the importance of the form number 7 is that we can ascertain the history of the land from the form number 7. That is, if suppose tomorrow you want to purchase the property, you want to verify whether the person who is selling the property is the real owner or not. And he said that I have purchased the property from this person, XYZ person. You have to see first whether that XYZ person names is mutated in the 712 extract, that is form number 7 or not. And then only we can proceed. Otherwise, it is just an what do you call it, the bogus entries. Okay, so this is form number 7. So far as form number 12 is concerned, please bear, uh, form number 12 deals with the entries of the crops which has been taken in that particular land. So therefore 7 and 12 it's a combination. And therefore it is always said it's a 712 extract. And in my notes I have intentionally attached, for example, one form numbers, the copy of the photocopy of the form number 7 and 12 for just example. Then we can find out the title itself say gaon namuna 7 व 12. So what is this? The gaon namuna means form number 7 and 12. Then the see, in 712 extract there are different 15 different aspects are provided. So what are these 15 different aspects? The first one is that so far as farm number 7 is concerned, the village name, then the name of the talukas. The first one, village name, name of the taluka, district. Then in the next line we have survey number or gut number, depends upon this whether the settlement has been done or the scheme has been there. Then the division, sometimes there might be a division in the one survey or in one gut. So whether there is a division has been carried out. For example, if the survey number is 1 and in that one survey number the property is belonging to X, but after the date of the X has 3 sons, then survey number 1 will divide it X oblique 1, X oblique 2, X oblique 3. This is called as subdivision. Then आपण put हिस्से असे म्हणतो, subdivision. Then fourth is uh, uh, if it is a occupancy is there, then what kind of occupancy is provided? It is also provided in the that particular uh, central extract, like we had discussed in section 20 also. We had discussed when the land is allotted class 1, class 2, class 3, and मग ते दिलेलं असतं Bogota 1, Bogota number 2, Bogota, or is it trust land. So that this is also reflected in the form number 7. Fifth aspect, that is name of the occupant, who is occupying the property, who is actually cultivating. ज्याला आपण मराठीमध्ये भोगवटादाराचे नाव असं, Bogota means who is actually occupying the property. Then this is another aspect, that is local name of the that particular land. Sometimes in village the land is titled or identified by the local village uh, by giving the different names, hypothetical names. Then another aspect, that is exactly after the column, that is with reference to cultivable area. And cultivable area means the area which is useful for the cultivating the land. And then there is a total, which total includes the put kharab also, that is uh, buried land which is not used for the agriculture purpose. Then that is the next aspect, that is uncultivated land. ज्याला आपण मराठीत पोट खराबा असं म्हणतो. पोट खराबा म्हणजे ज्या प्रॉपर्टीमध्ये शेती करता येत नाही असे पोट खराबा. अँड देन द टोटल ऑफ द लँड, देन assessment. That is why assessment. On the basis of this assessment you have to pay the land revenue, ज्याला आपण आकार असं म्हणतो. 3 रुपये 4 डिपेंड्स अपॉन दी कॅपॅसिटी. देन स्पेशल असेसमेंट असेल तर स्पेशल असेसमेंट, स्पेशली this kinds of column number 12 come in the picture when it is a what you call, when land is in respect of the MIDC purpose and all these special says and all this purpose, then this special assessment is concerned. Then it is most important aspect, that is khata number. Every occupant has given what khata number, like we have account number in bank. Cemental extract also deal with the khata number. So when you find out whether any person has land in the village or not, you just give the khata number to the talati. He will identify these are the lands belonging to, that is like permanent identified number of the occupant. Then the rent, if the land is on the rent, then what is the rent, lease, and the other rights. Now this 15 number is very interesting. Other rights. See why this other rights is concerned, because authorized person sometimes become or turn into the ownership problem also. Let us take example. Suppose, because this 15 is most important, you have land and you have taken loan from the uh, any agricultural society or the government by hypothecating this particular land to the particular bank. Then then the name of the bank from which you have borrowed the loan will be reflected in other rights column. Or prior to 1999, when you enter into practice, you realize, if you go to the 712 extract prior to 99, then you realize because of the sisters has not given the absolute rights that is equal to son prior to 1999, and there before that, that their names are already always reflected on other rights column, because they are entitled only after the death of the father. We know the notional partition, and therefore their entries are made in other rights column. So those persons who are having interest, so whenever you want to purchase the property, please go through whether the any other person apart from the property is having the interest in the property or not. Then uh, if you go through the all these entries, khate number, and there is a detail provided uh, in this. Come to the crop entry. Form number 12 deals with the crop entries. That's why it's a 712. It deals with the types of name of the crops, like we have jowari, wheat, gahu, uh, groundnuts, and all these. All these crop which has been taken by the cultivator, it has to be reflected. Or entry has to be made by the talati in that particular 7 extract. Why this? If say for instance, if you are taking the crops based upon the water, that is like sugar and all these things, of course the assessment will be higher. If it is seasonal, then assessment will be lower. This is just to understand the payment of the to pay the revenue to the government. Then name and the number of the fruit trees and the fuel trees. This is most important. If you remember session 2022, we have discussed all these aspects. How many trees are there in this particular land? It has to be reflected on 7 extract. Why I'm saying that, say for instance, suppose you are the owner of the property and you have 50 mango trees and other trees in your particular agricultural land, and tomorrow government wants to acquire the land for road purpose. Then as per the land acquisition act, the costing of the land and the costing of the tree is different. So when government has only paid you the amount of the land, and you are saying that, sir, there are 50 trees in the particular land, we are not paid for that, then government will see whether there is an entry in the 12 extract or not. So these entries are most important. The trees, that is the name and numbers of the fruit trees or other trees in that particular land. Then source of water, this is also most important, whether it is from the well, whether it is from the dam, whether it is from the borewell, all these sources has been reflected, or sometimes river also, it has to be declared and 12. Then sometimes the area of the grass, sometimes land is occupied by the other grass where you can't cultivate the land. Then the if you have the building, we call it the farm building. I'm not saying the other building, the farm building, and the other non-agricultural use, then you have to mention this under the farm number 12 also. Then uh, uh, apart from this, uh, very important entry that has to be made, that is the cultivation activities conducted by the agriculturists or occupant for cultivating the land, that is to be reflected in this form number 12. This is also most important entry so far as form number 12 is concerned. After this initial discussion, let us proceed with the provisions under this chapter. Especially, firstly, we'll discuss the particulars of the record of rights. Section 148 of the Maharashtra Land Revenue Code deals with what are the particulars which has to be included in the record of rights. And this section provides that as per the Maharashtra Land Revenue Code, in every village there has to be the register which has to be maintained the all the record of rights, and these the record of rights shall include the following particulars. Firstly, the first and of course the name of the person or those persons other than the of course the tenant, because tenancy rights is governed by the other laws, who are the holder of the land. I'm talking about the holder. I'm not talking about the ownership. Those who are holder of the land, those who are occupant, that is who are in the actual possession of the land, those who are the owners, the mortgages, the leases, if the land is lease on the basis of lease, then the name of the person who is cultivating or holding the land, if there is a government lease granted to the particular person, then the interest, nature of the interest of the person, it has to be mentioned in the record of rights. Then apart from this, the liability of the person, as we have discussed, if he has borrowed the loan, that liability has to be reflected in other rights column. These all things has to be reflected in record of rights. Apart from this, the rent or the revenue payable to such a person, it has to be reflected in the land records. And along with this, uh, if any special particulars prescribed by the state government, then it has to be recorded in the uh, what do you call it, record of rights column. There is new section provided under section 148A, which provide that, and now it is mandatory, because now since we have done all the 712 extract in digital form, therefore all these entries, whatever we have discussed under section 148, it has to be stored in the device. That is device created by the state government, like we have NIC, so far as Maharashtra government national informative centers, then it has to be stored in the electronic gazettes form. That is what section 148 is concerned. Now, once we discuss what are the particulars has to be discussed on the record of rights, there are several judgments given by the Supreme Court and the High Courts of Bombay. What is the evidential value of this record? Please bear in the mind, record of rights is not the documents of the title. Documents of title is something different. This is just for collection of the revenue. And the Supreme Court rightly in recently 2015 has rightly held that section 148 to section 150 of the Maharashtra Land Revenue Code, they are dealing with the entries in land records. They are nothing to do with the ownership of the lands. Ownership is something different. That is to be covered by the Transfer of Property Act and not by the Maharashtra Land Revenue Code. Here under this act, this is entries is made only for the collection of the land revenue. That is the person who has purchased the property, who has by succession got the ownership over the property, or by mortgage he become the owner, or by lease, or by the gift, or other methods he become the owner. Then his name has to be reflected by this mutation entry in the 7th extract. The Supreme Court very interestingly held in the particular judgment that the only because the name of the person is reflected and the position is with some other person and the owner has not objected for the position, that doesn't mean that he has impliedly consent for that. That consent is different and the ownership is totally different. This there are several judgments given by the Supreme Court so far as the mutation into this concern. Now, after this record of rights, let us discuss what is the procedure for mutation the name of the person in the record of rights. And the procedure is provided from section 149 onwards. Firstly, under section 149, you have to make an application. And who are entitled to make an application? Section 149 is very much clear. It's provide that the person, any person who is acquiring by succession, by survivalship, by inheritance, by partition, by purchase, or gift, lease, or otherwise any rights in that particular land, or by the mortgage or anything, then he has to make an application to the in writing, mentioning the particulars, the method of acquiring the rights to the talati within 3 months from the acquiring these rights. And after receiving the application, of course, if the person is minor or he is suffering from any other disability, then the guardian or the other person in this behalf, uh, he can make an application. However, if the land is purchased or the ownership is acquired with the permission of the collector, that is by the collector itself, then there is no need to make an application because already there is a permission by the collector. So uh, this is the first step, that uh, the person has to make an application to the revenue officer for the mutation the name. Once this application is made, then next procedure started, that is entry in the register. This is what section 150 is provided, and purely it's a official work of the revenue officers. Once this application is received under section 149, then uh, uh, it's a duty of the talati to enter the mutation, the name of the person. But before entering the name of the person, as provided under section 150, 54, that what he has to do, he has to receive the documents from which he has received. Say, for instance, he purchased the property, then he has to receive, after receiving the document of the title, that is sale deed or the mortgage deed or any other document, then he has to issue publish the notice, and that notice to be given to the interested person. Suppose the earlier purchaser whose name is reflected in central extract, and apart from this, he has to issue the publish the notice in the chowdi of the particular village that a certain person has acquired the rights. Anyone having the objection, then he can raise an objection. Not only this, nowadays this particular notice has been sent by registered post ID also to the interested person. And once this particular notice has been served to the interested person, then the person the person who has an interest in the property, if something is fishy in the documents or the owner transfer, then he can raise an objection, and that objection has to be decided within raised within the 13 days from the receipt of publication of the notice. Now, why what is the most important under this aspect? Let me tell you, because once you enter into practice, you are going to face this aspect. As per this section 150, it is not necessary that if you purchase the property by a registered deed like sale deed, then it is not the duty of the purchaser to file application under section 149 to the talati. Rather, it is the duty of the registrar to send the intimation to the talati that now Mr. X has purchased the property. You carry out the mutation entry by following the procedure under section 150. But however, when you enter into practice, you will realize most of the matters are in on this point, and we people, that the lawyers and of course the officers, have wrongly interpreted this aspect. As per section 150, when there is a ownership is acquired by the registered deed as per the Registration Act, then it is not the duty of the person who has acquired the right. Rather, it is the duty of the registrar to intimate the revenue officer that now you can mutate the name of the this person in place of the earlier person. So this is very interesting aspect provided by the 150. Now, if someone has raised an objection, 150 has provided that uh, the objection has to be decided within 1 year from the date of objection, and whatever will be result, he has to pronounce the judgment within 1 year. And if there is disputed entries, there is another form we call as 7b. I'm sorry, 7a, 7a, and 7b. That in respect of which he has to make an entry that in this respect of land there is a dispute is pending in the revenue authority. That entry has to be made under as per section 150. Once this notice or intimation is there, then there are certain obligations on the revenue officers prescribed. And let us discuss what are those obligations on the revenue authority. First is duty to furnish the all the information and the maintenance of record. As we discussed, that the revenue officer, that the talati, it is the duty of the talati to maintain the record of rights in respect of the lands after registration and so far as the revenue collection of the revenue is concerned. Apart from this, whenever any person uh, file an application for uh, to search the title, then it is the duty of the revenue officer to intimate the exact information in respect of the land, and that has to be provided immediately. Who are the holder of the land? Who is the occupant of the land? Whether the dispute is pending in respect of the land or not. And interestingly, it, all this information has to be provided free of cost. So this is very important duty cast upon the revenue officer so far as the section 150 is concerned. Apart from this, section 154, I'm sorry, 152 provides that if any person who fails to intimate the accurate information to the revenue officer, or who fails to inform the change of the use of the land or the intent, then the authority, that the government authority has a right to award the fine, and that fine is charge of fine. That fine is the it not exceeding 5 rupees, of course, per month, or depends upon the land revenue of the particular land. This is what section 152 is concerned. Now, so far as the another duty is concerned, duty to that is what section 154 is concerned. 154 deal with a very interesting aspect, that as I already told you, that whenever the ownership of the lands is transferred due to the documents, then it is the duty of the registering authority that he has to intimate to the revenue officer that now the ownership of the particular land has been changed due to this document, and this intimation is to be given as per section 154 by the registering authority to the revenue authority. That is what I'm saying, that it is not the duty of the person who acquired the rights, rather it is the duty of the registering authority to intimate to revenue officer. Now you make an entry in this regard. So this is very interesting aspect, but unfortunately, most of the revenue officers they fail to understand, and most of the lawyers they have misinterpretation these aspects. Now, so far as the power to correction is concerned, section 155 deals with this aspect. Of course, if there is entry is made, then whether that entry is correct or not, this power is not covered under section 155. Section 155 of MLRC deals with the correction of clerical error. If if suppose while mutation the entries in the land records, some clerical error has been occurred, then the collector has a power to correct it, or he may direct the revenue officer to correct it. But that doesn't mean that you can mutate the name of the person or you can decide the matter. This is just a clerical changes, like we had discussed under the CPC. some clerical changes powers provided under section 152 of the CPC. If there is any clerical or typical mistake, then that can be cured by the officer. Now, so far as the presumption value of the mutation entry is concerned, 157 deals with this aspect. As there are several judgments that it speaks that the mutation entries is not a document of title; it is just for the collection of the revenue. However, if you remember the Indian Evidence Act, then you realize that it has a certain presumptive values. What is the presumptive values? The person whose name is reflected in the cemented extract, he is presumed to be the occupant of the land as per the uh, section 105 of the Maharashtra Land Revenue Code. This is what section 157 says. It has presumptive value unless it is rebuttable by the party. So, unless it is rebuttable, it can presume that he is the owner, he is the occupant of the property. And lastly, there is very interesting aspect provided so far as section 150 is concerned, that it says rather there is a bar to file a civil suit. It says that no suit shall be lies against the state government or any officer while performing his official duty who has correct the entries in the mutation entry. Then there is no suit will be filed against that officer in any court, any civil court in the law, if he has acted within the four corners of the law. Of course, appeal is lies, but no civil suit is being filed. This is what the chapter number 10, so far as record of right is